I want to thank everyone for coming to this event, and we are going to start our panel now. We're going to have a dramatic entrance by President Wydra, but she's parking her car, this wonderful DC traffic that I don't miss, and so she'll be here momentarily. I am going to start with an intro. You may wonder why the moderator is giving the intro. We had a call to plan this, and they unanimously voted that I give the intro. In law school, they always said the A students would be professors, the B students would be judges, and the C students would be millionaires. And so the A students wanted to hear the B student go first so they could correct all of my misconceptions about originalism. So the name of the panel is What is Originalism? And I thought, what better to start with than what is originalism? In its most basic form, originalism is the idea that the Constitution's meaning was fixed at the time of the founding, and that this meaning constrains judges. There are many strains of originalism. Indeed, many would say for every 3 originalists, there are 4 theories of originalism. And you are about to hear 6 different theories from the A students. Today, however, many originalists, and especially originalist judges like myself, believe in original public meaning originalism. In practice, when we are doing this inquiry, we are looking at how the people who ratified the words would have understood them, since communication needs both a speaker and an audience. After all, to interpret any document, we look at the words of the document. Think of how communication works in general. To understand what I am saying right now, your mind is interpreting my words as you understand them. If we want to figure out what something meant 100 years ago, we have to look at how people understood the words at the time. Think about a contract between 2 parties. To understand what the parties meant, we look at how they understood the words at the time. There's a great law review by Gary Lawson in the front row called On Reading Recipes that gets to this exact point, and it's worth reading. I also believe originalism is compelled by the oath. As a judge, and here is the dramatic entrance I promised. Elizabeth, I said I don't miss DC traffic.
That's terrible.
In Kentucky. I also believe originalism is compelled by the oath. And the very first thing you do as a judge is you take an oath. And you should pay attention to the oath. The text of the oath clause in Article 6 supports just that. It says that we take an oath to this Constitution. It says this, being the important word, Constitution. Not a Constitution of our liking, but this Constitution. Again, meaning the words and concepts in the Constitution as ratified and subsequently amended. That is originalism. The Supremacy Clause also uses the word this Constitution. It says this Constitution is supreme and judges are bound by it. As Randy Barnett says, and I love this saying, it is the law that governs those who govern us. In other words, judges and public officials take an oath to this Constitution. Alexander Hamilton made exactly the same point as Professor Barnett in Federalist 27. I think he was kind of reading into the future when he said the Constitution is the supreme law of the land and that all officers, legislative, executive, and judicial will be bound by the sanctity of the oath. And the oath is especially important to remember as a judge because, as Chief Justice Marshall said, we have the ultimate say to say what the law is. And we know all of this because of a more basic point. The Constitution was written, unlike in England. The existence of a written Constitution suggests that we are obligated to follow it. If not, what is the point? And so now I will turn to the A students to tell me what I got wrong. And I'll start with Evan Bernick, who is clerking for the brilliant Judge Sykes.
Thank you, Judge. What is originalism? Big question. I spent what was probably an unhealthy amount of time last night trying to formulate a precise and accurate definition that would be uncontroversial. I eventually gave that up and fell asleep and didn't satisfy myself that I had a definition. So when I woke up this morning, I decided I would set more modest aims for myself. I would say a bunch of things about originalism in general that I believe to be true, some things about my form of originalism that I know to be true, and just see what happens from there. So bear with me. One way to get a feel for what originalism is to understand two distinct but related claims that originalists tend to make. The first claim is a descriptive claim. The original meaning of the Constitution is law. The second claim is a normative claim. Public officials ought to follow the original meaning of the Constitution. So if you find yourself in conversation with somebody here today who's making either or both of these types of claims, you're probably talking to an originalist. Actually, if you're talking to anybody in this room today, you're probably talking to an originalist. That's a safe assumption. So what is the original meaning that originalists say is law? Early originalists tended to talk about the original intentions of the Constitution's framers. As Judge Thapar pointed out, most originalists today don't talk that way. They talk about the conventional or public meaning of the Constitution's text, what a reasonable reader of the Constitution would have understood the various words, phrases, and symbols that make it up to mean at the time that it was ratified. Of course, language is imprecise. Just read Federalist 31. And of course, historical research is hard. It's not always clear that interpreting constitutional text is going to give you a clear answer to litigated constitutional questions. So what do? Well, originalists disagree. Some originalists argue that originalism's domain is limited to the interpretation of text, and that whereof originalism cannot speak, it ought to be silent when it comes to the implementation of text. I am not one of these originalists. In my view, following the original law of the Constitution entails not only following the original meaning of the Constitution's text when it's clear, its letter, but when it's not clear, having recourse to the original functions of the Constitution's text, its original spirit. So, when a public official encounters constitutional unclarity, he should have recourse to the publicly available functions that those who ratified the Constitution into law would have associated with that textual provision at the time it was ratified. And he should formulate a statute, a regulation, or a doctrinal rule that's designed to implement that text. So there's the letter, and there's the spirit. Now, why should public officials follow either the letter or the spirit of the Constitution? There are a variety of normative arguments for originalism. The first is a kind of ontological argument. It follows from the nature of a written constitution and what ought to follow the original meaning of that constitution. The second is a democratic will or popular sovereignty type argument. The original meaning of the Constitution expresses the will of the sovereign people, and anything less is undemocratic. The third is kind of a consequentialist argument. Following original meaning will generally lead to results that, all things considered, are better than following some form of non-originalism, whether for the sake of liberty or for the rule of law or generalized social welfare. Picking up on Judge Thapar's comments, I want to throw one more normative argument into the mix. Originalism equips public officials to fulfill a promissory obligation. Promising is a valuable social institution. Most people think that they ought to keep their promises and that other people ought to keep their promises to them. Every public official makes a promise pursuant to Article 6 of the Constitution to support this Constitution. And there's no compelling reason to believe that the original public meaning of this Constitution, as Judge Thapar has just described, differs substantially from the contemporary public meaning of this Constitution that public officials take. You very rarely see public officials claiming that they are bound to support a different constitution than the one that went into effect in 1788, as validly amended, that they took an oath to a different fundamental entity than did Washington. As a consequence, both the original public meaning of the Constitution and the contemporary public meaning of this Constitution refer to a historically situated document that received its meaning when it was ratified into law. Now, not all promises carry a significant moral obligation. Think of an assassin's promise to kill someone. And I'm prepared to say that had we an evil constitution, that required systematic injustice, I'm not necessarily sure that a promissory obligation could be supported on the basis of an oath to follow it. However, we have a reasonably, if imperfectly just Constitution that provides for a scheme of social cooperation that secures the liberty and the welfare of the people who live under it reasonably well, better than any reasonably available alternative. And that's enough to support a moral obligation on the part of public officials to do as they've promised to ensure that the Constitution delivers on its promises. Originalism equips public officials to discharge that moral obligation.
Thank you. Next, we'll have Professor Balkin, who is the Knight Professor of Common Law and the First Amendment at Yale Law School.
Hello, everyone. I am delighted to be here. It is nice to see you all. I thought I would tell you a little bit about my own theory of originalism. I guess we're all going to tell you about our own theories. My theory has different names. Sometimes it's called framework originalism. Sometimes it's called living originalism. But I'll try and explain what this is all about. So, framework originalism. So what's a constitution for? Well, a constitution like ours basically serves many functions, but one function it serves is the following. It helps make politics possible. In other words, it helps people to have a framework in which they can struggle over power and whatever else they want through constitutional limits instead of just a free-for-all. So constitutions are designed to make politics possible, and they make politics possible by constraining politics within a framework. And so the idea of framework originalism is to figure out what's in the framework. And here's my view. The framework is the original meaning of the words and phrases in the Constitution and the adopter's choice of rules, standards, and principles. That's what the framework is. Now, why do I mention rules, standards, and principles? Very simple. If you and I were going to design a constitution together, we would find that sometimes we wanted hard-edged rules that were very difficult to get around and didn't take much work to apply. But we would also find, especially if we were designing a Bill of Rights, for example, or some other parts of the Constitution, we'd have to use standards, unreasonable searches and seizures. Sometimes we'd even have to use principles, freedom of speech, freedom of religion. And so if you look at constitutions around the world written after the American Constitution, you'll see they have a combination of rules, standards, and principles. The framework is the original meaning plus that choice. And then there are a bunch of other basic principles that you're very familiar with that are also part of the framework. In the American Constitution, we have separation of powers, we have federalism, we have the rule of law, we have a commitment to democracy and a commitment to a republic, that is, a Republican form of government. These things are not always directly stated in the text, but they're implicit features of the kind of constitution we have. Okay, what it means to be an originalist, from my perspective, is to be faithful to that framework. Okay? Now, it turns out that history plays a big role in what it means to be faithful to the framework. History matters in figuring out what the original meaning of the words and phrases is. History matters in deciding whether we have a rule, a standard, or a principle. History matters in deciding what principle we have. And history also matters in the next phase of constitutional interpretation, which is what is sometimes called construction. Because when you have a constitution that has gaps or silences or has rules, standards, and principles that require some degree of judgment to basically apply in new situations, you will have to use the text in order to judge. Now, when the text has a rule, you apply the rule because that's what the text says. When the text has a standard, you apply the standard because that's what the text says. When you have a principle, you have to apply the principle because that's what the text says. But when you apply a principle, sometimes there's more than one possible answer. That's why you need construction. Construction is an action of judgment. It requires that you spend time thinking about how best to be faithful to the Constitution. How do you engage in construction? Well, I could write a whole book on this. In fact, I'm writing one right now. But, very simply, lawyers are not at a loss when they engage in construction. There are a bunch of standard techniques and kinds of arguments that lawyers use, and those are the ones that you're supposed to use when you engage in construction. You know them all. You make arguments from structure. You make arguments from precedent. You make arguments from custom. You make arguments from convention. You make arguments from the history of the United States and its traditions. You make arguments from the nature of the American Constitution and the nature of the Constitutional Compact. These are all very familiar arguments. You know them all if you went to law school. They're basically second nature. This is the task of people who are engaged in construction. Now, here's the last idea I want to give you. Mine is also called living originalism, which is a mixture of living constitutionalism and originalism. That may seem very strange to you. You thought they were opposed. No, not at all. In fact, they are two sides of the same coin. But my version of a living constitution is a little different than the version of a living constitution that you may have heard of or thought about. All I mean by a living constitution is this. In each and every generation, it is the obligation of that generation to apply the Constitution's rules, standards, and principles in their own time, based upon the tradition that they have received from the past generations. That is their duty. As they do it, as new laws are passed, and as new decisions are rendered, as new constitutional controversies arrive, they will be adding to that constitutional tradition. They will be producing something to what they had before. That process of addition, of construction over time, is what we should call a living constitution. Understood in that way, there is no contradiction or conflict between the idea of fidelity to original meaning, that is the framework, and the construction of the Constitution over time, which is the proper way to think about what we have when we talk about a living constitution. Thank you.
Thank you, Professor. Now we'll move to Professor John McGinnis, who's the George C. Dix Professor in Constitutional Law at Northwestern University.
Well, thanks very much. I'm going to explain what Mike Rappaport, who I write with about these matters, and I think is the best form of originalism, and it's called original methods originalism. And I can do that, I think, a little bit by contrasting our position with Evans and with Sachs. First, I don't agree it's an analytic truth that originalists should seek the public meaning of a provision. As Evan notes, some have thought the proper object of interpretation is the intent of the framers. I don't think we can decide that question as a matter of contemporary linguistics or philosophy. It depends, crucially, on the methods of interpretation that were expected to be applied at the framing, those original methods. One colloquial way of, I guess, expressing this is I'm in favor of originalism squared. We not only look for the original meaning, we look for it through those original methods. These methods were key for both positive and normative reasons. Positively, the meaning of a text, particularly a complicated text like the Constitution, must be a function of the methods that were used to decode it. Otherwise, you won't get some other meaning. You won't get the meaning that was fixed at the time. Moreover, using these methods is normatively attractive. After all, it was the meaning as fixed by the applicable interpretive methods that got the supermajority of votes that makes our Constitution fundamental law and likely good law. And as a matter of historical fact, I do agree that the object of interpretation at the time of the framing was intended to be the public meaning of the document. That's what the jurists at the time showed they wanted. But it doesn't follow that the meaning was what a casual reader would have understood it. To the contrary, context is what is essential to meaning. And the most important context for the meaning of the Constitution is its legal context, which implies that the key meaning of it is often its deliberated legal meaning. Sometimes that meaning coincides with what a layman would ascribe to it, but sometimes it's supplemented by a meaning that would be completely clear only in a legal context. We understand that in ordinary life. Often people say, well, I think this is what it means, but really, for a detailed answer, ask a lawyer. The centrality of the legal context for the meaning, I think, is clear from the history and the document itself. The Constitution wasn't created ex nihilo, but against a background of legal texts, like statutes, and indeed state constitutions. On its face, the U.S. Constitution declares itself to be law. It was put into final shape by the Committee on Detail. And who was on that Committee on Detail? The greatest lawyers of the convention. It is scores of terms, I've counted them, that are obviously legal, and hundreds others, I've counted those as well, that might be legal depending on our rules of interpretation. It even contains provisions that embed legal interpretive rules. One of those is the so-called non obstante legal interpretive rule contained in the Supremacy Clause, anything to the contrary notwithstanding. That rule eliminates another legal rule that might have been applied that favored harmonizing state and federal law even when they were in tension. Thus, the substantial legal context, legal references, and legal vocabulary of the Constitution all show that it was expected to be interpreted according to the relevant legal interpretive rules of the time. As a result, I have to say I do disagree with those like Jack, who thinks the Constitution is essentially an open-ended framework to be filled in often by construction. The view of the Constitution as a general framework was certainly accurate as applied to Britain's unwritten Constitution. But as William Patterson, one of those great lawyers on the Committee of Detail, said, the glory of the American Constitution was, quote, it was reduced to written exactitude and precision. There's simply no evidence from the early republic that judges were thought to have a power of construction separate from interpretation. That suggests that they had a rich understanding of what could be gleaned from the words of the Constitution. And to the question of the work of each generation, the Constitution sets that forward itself. Each generation adds to the Constitution fundamentally through the amendment process. To be sure, the proof that the constitutional law can be generated mostly by determinate legal meaning is ultimately an empirical one. But I'd end by noting that we really live in a golden age of originalism. Scholars are continuously finding more precise meaning by looking at clauses that might have been thought to be open-ended and indeterminate, like due process, the Eighth Amendment, privileges or immunities, and yes, even unreasonable searches and seizures, and finding that these actually have relatively clear legal rules when understood in the legal context. What they are doing is they are resisting the idea that when clauses are not clear on their face, we go to construction. Instead, what they're doing, as I think the interpreters of the Constitution did at the time, they're choosing the better interpretation based on all the available method, even if that interpretation is only somewhat better than the alternatives. Indeed, I think today the greatest achievement of originalism is the meticulous unpacking of carefully drawn provisions of the original Constitution and its all-important amendments. Thank you.
Thank you. Next, we'll go to Professor Sachs, who's a professor of law at the Duke University School of Law, to reconcile all this and give us a theory.
Sure thing. Thank you all very much for taking time out of your Thursday to come hear us in the morning. I've seen at least one former student in my originalism seminar, so I apologize to him if some of this is familiar. Trying to sum up what's gone thus far and reducing it to some extent to slogan form, I'd say that originalism is following the founder's law. Or to have a slightly longer slogan, and stealing a page from Chris Green at Mississippi, you could say that America has the oldest continuously operating written constitution in the world, is another way to state originalism. That we have the oldest continuously operating written constitution in the world. If you think that, and many people do, you might be an originalist. So what do I mean by that? So let's start at the end. Written constitution. We do not have an evolving, customary, common law tradition that is our Constitution. We are a common law country, we do have common law rules, but we do not have a common law Constitution. Instead, our Constitution is an enactment. It's a legal document that was adopted at a particular time. It added some rules to the legal system, and those rules stay as they are until they are lawfully changed. In order to figure out what the Constitution added, we have to look back to the original law. So if I could add one more level on top of John's, if he's going to do originalism squared, I'd say originalism cubed. We use the original law to find out what original methods are properly used to read this original text and find its original meaning. I'm sure we can get up to fourth and fifth powers later on. Second, originalism says that we have a continuously operating constitution. The written constitution, that old one from back then, is still good law. When you're making a legal argument in the American tradition, you can't say, the way they might say in France, well, that was the Fourth Republic, this is the Fifth Republic, and we just do things differently now. You can't say, well, the Supreme Court went the other way, or, well, the New Deal happened. Nobody in our system is given legal authority to change the Constitution, except in the way the Constitution actually lays out. The Supreme Court can, I know it's shocking to say, sometimes be wrong on the law. But the Constitution of 1788 can't be wrong on the law, although it can be amended. That means that you've got to have some theory for how you get lawfully from the founders and the founders' law to today. This is a claim not just about how you read the text or how texts have to be read. I mean, you can read the Constitution in lots of ways. You can read it as a prose poem. You can, use it to line a birdcage. It's about preserving the rules that the Constitution laid down and that remain in force over time. The text is there to preserve whatever rules the text actually made at the time that it was adopted. And finally, we have the oldest continuously operating written constitution. We're looking at a very old document. That means it might turn out sometimes to be bad policy. It might not do the things we want it to do. But while the Constitution might turn out to be bad policy, it can't, as I said, be wrong on the law. And when we follow the Constitution, we're not necessarily following it because we think everything it does is good or that everyone who made it was good, any more than we follow ERISA because of some sort of, patriotic piety towards the 93rd Congress and President Gerald Ford. It's just, they might have been great, but ERISA is law today because it was enacted and has never been repealed. And that's how things work for enacted documents in our system. The same is true of the Constitution. And that's why, if we're talking emoluments or impeachment or the take care clause or recess appointments, arguments very naturally fall into an originalist register. Because whatever powers George Washington has, the occupant of the White House has today, whatever powers Congress had in the first Congress, the current Congress does too. This is the orthodox way of defending legal claims in our system, and that's what makes originalism our law. So many of you may have thought already that you are originalists. Some might be surprised to discover that you are originalists, sort of like the character in one of Moliere's plays who was surprised to discover, like, wow, I've been speaking prose all my life. You might have been making originalist arguments all your life and only realize it now because all that originalism is following the founders' law. Thank you.
Next, we're going to hear from President Wydra. Elizabeth Wydra is the president of the Constitutional Accountability Center, and she's going to tell us why everyone before her is wrong.
Thank you so much, Judge, and thank you so much to everyone for being here this morning. I always enjoy coming to speak to the Federalist Society, in part because of great discussions like these. So one thing that I've heard a lot of from the folks who've spoken already is talking about the powers of President Washington or the First Congress. And while I consider myself to be a progressive originalist, perhaps one of the most important things that I feel is left out of the originalism discussion generally is the whole Constitution. The amended Constitution is just as much part of the Constitution as the Constitution as it stood in 1788. We, the people, over time, have taken advantage of the founders' genius in putting in the amendment process to make the Constitution, over time, more democratic, more inclusive, more just. And I think that is an incredibly important thing to keep in mind when we think about who we are as a nation, when we think about what our Constitution means, because there were some systematic injustices at the founding. Fortunately, we the people remedied them through the constitutional means given to us. We got rid of chattel slavery through a constitutional amendment. We ensured that women and people who were of low economic means who couldn't afford a poll tax were included in democracy through the amendment process. We made sure that equal citizenship was enshrined in the Constitution through the amendment process. And so to privilege the original Constitution over the whole Constitution is something that I think is a grievous error and something that happens sometimes when we talk about originalism, but is something that we should all keep in mind when we're making legal arguments, when we're making value arguments about constitutional democracy. I think it's also important to remember the whole Constitution when we talk about federalism, because federalism was one of the great inventions of the 18th century Constitution. But it was drastically changed by the second founding, as some of us call it, after the Civil War, when we enacted the 14th Amendment, when we gave Congress enforcement powers under the 13th, 14th, 15th, and then subsequent rights-enhancing amendments. Obviously, we still have a federalist system, and thank goodness for that, allowing us to have state and local innovation as well as national power to solve national solutions, to provide national solutions to national problems. But that federalism was changed after the Civil War. And to not recognize that, I think, means that you aren't actually a real so-called originalist, someone who cares about the meaning of the words of the Constitution. But I think that everyone here is not wrong. I think that the methods and the ways that we talk about how we do originalism is an important conversation. But I think that in some ways we have more in common than we have, differences between us. Now, I'm not going to say I'm doing originalism squared or cubed or taking the square root of it or whatever. But I think, as the good judge said, if not, what's the point? People from all sides of the ideological spectrum should be grappling with, should be arguing about the words of the Constitution. If not, what was the point? What was the point of our founders writing it down? What was the point of these generations pouring blood, sweat, and treasure into changing the Constitution if we aren't going to take it seriously? And I love talking about that with more conservative or libertarian audiences like this morning. I love talking about that with my fellow progressives at those gatherings. And it's something that I think we should all agree on. Also because, as Jack said, it fosters better politics, frankly. When the Affordable Care Act was first passed, I did a lot of debates across the country, particularly with Randy Barnett. And we would get up there and we would argue about the Committee of Detail and what they meant when they gave the Commerce Clause power and all of these things. And not only did it make for, I think, a better conversation, but also if he got up there and talked about that and I got up there as a progressive and said, who cares? That's not a very good debate. I guess you'd get to dinner easily, faster, but, that's not a very good discussion. That's talking past each other rather than grappling with what does it mean to have a limited government? What does it mean to also want to provide for quality, affordable health care? So I think that it fosters better politics, as Jack said. But one thing that I think is hard to get past when I talk about the idea of how all of us should come together around the text of the whole Constitution is that the label originalism does carry some baggage, especially for folks from the leftward side of the ideological spectrum, which is where I sit. Very few people these days actually practice the caricatured vision of originalism, where, you do a seance to try to think of what James Madison would think about, applying Fourth Amendment protections to the internet. No one really does that. We talk about different ways in which you can do it, and there can be some methodological differences about how you practice originalism, but no one really does that caricatured version of originalism. And so then we talk about, what was the original meaning of these words? What was the original meaning of due process? How does that change things? That's a real debate that I think everyone should be having. And frankly, the idea that only conservatives are originalists and liberals aren't is just wrong. And you can look at the Supreme Court to see that. You can disagree with the way that folks on one side or the other apply it. But, as we've heard from Justices Kagan and Ginsburg, if you're talking about looking to the text and history of the Constitution, they're originalists too, and they've said that at various points. So I think that, again, there's more that we have in common that divides us on this particular question. Maybe, on the left, I'll have to think up a new word since originalism kind of gives everyone hives, but I haven't come up with that slogan yet. We can talk about some workshopping some of those things. But finally, I just want to say, in terms of the if not, what is the point? The words of the Constitution are also valuable to us because they give us a North Star. It took the Civil Rights Acts to bring reality to the promises of the 14th Amendment. We are constantly working to live up to the words of our Constitution. And so in that sense, I think thinking about the original purpose of the Constitution is not just important as a legal matter, but inspiring as an American.
Thank you very much. Finally, we will hear from Professor Christina Mulligan. She's the Vice Dean for Academic and Student Affairs and Professor of Law at Brooklyn Law School, and she's going to clean all this up.
Only kind of. The previous speakers have spoken about what originalism is, but these comments are going to address more what originalism is not, or at least does not have to be. Not presenting a separate theory, but presenting a way of approaching the theories that we've just heard. Many critics of originalism discount it or see it as illegitimate because they perceive it to be a tool for conservative white men to maintain their power over legal society. And it certainly does seem like originalists are largely conservative or libertarian or Republican, largely white and largely male. But that's not what originalism has to be. Originalism can be more diverse in many ways, and that diversity can be leveraged to make originalism better while sticking to the values of fixation and constraint central to originalism. Now, talking about diversity and originalism with different audiences is a really interesting experience because different audiences are inclined to embrace and reject different parts of these claims. So with this audience, I expect the notion that originalism is a valuable method to be a relatively easy sell. You might reasonably think, listen, either originalism is the correct way to interpret the Constitution or not. That doesn't change if the people who like originalism right now are conservative or white or male. If that's how the law works, originalism is just what we're legally obligated to do. But I expect the harder sell is this, that originalists can learn from the critiques of originalism that say it has problems with sex and race because those concerns get at something real and important that we can address today while still being originalist. Or maybe in other words, just because you disagree with how some people on the left talk about race and gender doesn't mean there's nothing to talk about. The key insight for originalism is to recognize that some criticisms of originalism are about the past and some criticisms of originalism are about the present. The criticisms about the past, that the framers were white, that the framers were male, that the framers are dead, are things that we can argue about the relevancy of, but we can't do anything about them. But focusing solely on the identity of the framers misses most of the weight of the criticism of originalism surrounding sex and race. Counterintuitively, many criticisms of originalism's relationship with sex and race are actually about what originalists do in the present. So what are these present-day criticisms? First, that originalists are homogenous in terms of their political beliefs and social experiences, and so we're all more likely to interpret constitutional text the same way, perhaps more likely to see what we would expect given our own beliefs and experiences rather than what the framers or what the amendment ratifying era populations actually did believe. Second, that originalists focus too much on sources by the founding era elite in contrast to other historic populations. And the third criticism, that originalists and people associated with them today, Republicans, conservatives, libertarians, just don't really care about the rights and liberties of women and people of color. So why trust originalists if they advocate for a document that ostensibly symbolizes these racist and sexist problems? So each of these concerns can be addressed today while being faithful to originalist methods. And I think addressing each of these concerns makes originalism better on its own terms. So for example, a less biased originalism is one in which those doing the interpretation come from a variety of perspectives. So it's important to value having a diverse population doing originalist interpretation for its own sake. Elizabeth brings a different perspective than John, and while neither is more likely, that Elizabeth and John on this panel, not like a hypothetical Elizabeth and John, and while neither of them is more likely to be right based on who they are, based on the fact that they're female or male or progressive or conservative, the fact that they look at the same evidence with a different different eye increases the likelihood that they're going to be able to see different things and correct each other's mistakes. A better originalism is also one that looks to a variety of historic sources. Black people and white women were present and speaking and writing throughout the Constitution's history, most especially during the discussion and adoption of the Reconstruction Amendments. They constituted the public that makes the public meaning as much as anyone else, and we can pay more attention to them even though many of these authors are relatively obscure. They're there. And self-promotion alert, some of these texts, discussions of some of these texts appear in my article, Diverse Originalism, if you want to look it up after the panel. Finally, and most challenging, we can start to address the alienation that many people feel from originalism and from the Constitution in a couple ways. First, we as originalists can be conscientious about applying our enthusiasm for originalism equally across legal issues. If you believe the original meaning of the Second Amendment protects the right to bear arms, make a point of emphasizing that equally, whether a gun owner in a particular case is white or black. Second, we can be more careful to separate the morality of the Constitution from the failings of the people who wrote parts of it. To analogize from a simpler case, whether the Declaration of Independence espouses good values does not depend on whether Thomas Jefferson was a good person. Thomas Jefferson spoke with excruciating clarity about his belief in the inferiority of black people in his notes on the state of Virginia. Yet, the Declaration will always be a beacon that reminds us all men are created equal. So to answer the original question of what is originalism, it's a method by which we interpret legal meaning today through appropriate reference to yesterday. And to the extent we choose how to approach that interpretation today, we have a great deal of latitude in how well we can be originalist and how big a tent we can build.
Thank you very much. And for those of you that were trying to scribble fast, it's called Diverse Originalism, is Christina's article. And it's worth reading. So I'm going to start with the questions. Justice Scalia is looking down on all of us and smiling because he used to say that when he was an originalist, people would go running from the room. And when we announced this panel, everyone kept streaming into the room. But as Elizabeth pointed out, some people now get hives when they hear the term originalism. So do you think originalism is a useful label and why? And after hearing all of your theories, are you all really under the same tent? And I'm going to start with Professor McGinnis and then have Professor Mulligan comment.
I think it is a useful label. Larry Solom, who's a professor at Georgetown, says originalists have a family of theories, and they do agree on certain things. They agree that the meaning of the Constitution was fixed, either analytically or perhaps as Steve and I do, contingently because of original methods or the law, and that's a very important matter. The meaning of the Constitution was fixed at the time it was enacted. And secondly, we think it should at least contribute to the constitutional law today. The difficulty, of course, is that even in families, there are black sheep. And also in families, the other difficulty is we don't agree on who are the black sheep. And so there are a lot of divisions within originalists. And so I would just note three large matters that may, while that analytic point is absolutely true, that may divide us more in practice than unite us in theory. And so let me just lay them out very briefly, because I think you should look for them. This will be discussed throughout this weekend, the conference. I think the first is how thick the meaning of the Constitution is. How much is done by interpretation and is fixed? How much is done by construction and is more open-ended? We saw a big difference between Jack and myself on that. Another question is, how much should judges be aggressive in using the Constitution to invalidate the views of other branches? Judicial engagement versus judicial restraint. How can that be fixed in the meaning of the Constitution? And finally, precedent. There are just thousands of Supreme Court cases, not all of them originalists. What is the theory of originalists have with respect to precedent? Many of us have very different theories with respect to precedent. Some have no weight to precedent, others give it a great deal of weight. So those practical issues, I think, actually divide originalists more than unite them. But there is a core that we all share.
Thank you, Christina.
So I took this question from a little more of a PR perspective, and does originalism as a label do the work that we want it to do? And I don't know the way out of this, but a challenge with the label originalism is that it kind of evokes this kind of founder worship and wanting a historical golden age to return that people kind of more left of center might find suspicious, even though it's not really core to what originalism is and is doing. And I get where it comes from, that it comes from kind of rejecting a kind of freewheeling living constitutionalism and trying to situate it in a particular thing, place, and time. But I get a lot more mileage out of not emphasizing the original part. So one of my colleagues before I came here says, why would anyone be originalist? Like, this is just some completely wild idea. And I was like, well, how do you interpret a statute that was passed in 1905? Right, and like and that kind of led off into a discussion of like, this is just how law works, much as Steve Sachs and Will emphasize in their work a lot. And so kind of emphasizing more, we're just doing law, this is how law works, I think makes it easier from a public relations perspective or an expansive perspective to convince people who are very nervous when they hear the word originalism because they think it means having to embrace other aspects of the 1780s, that's not what it has to be. I don't know what other word we would use because it's the word, but I think it's something to keep in mind.
Thank you. So let's answer Christina's colleague's question. Why should someone be an originalist? And Evan and Jack, why don't you all tackle this? So Evan, you want to go first?
So yeah, I think that as an initial matter, just figuring out what the law is a useful thing, regardless of whether you think the law is good or bad. Steve brought up ERISA. Simply knowing where you stand before the coercive apparatus of the state is a valuable thing, if only because, to the extent that you don't understand it, you can't see what's wrong with it, and you can't change that in ways that would be more conducive to your normative convictions. The other way, though, that originalism is valuable, at least to me, and the reason that I'm an originalist, is I think that the original Constitution is pretty good. It sets up a just scheme of social cooperation. It's worth preserving, insofar as I'm interested in establishing justice, securing the blessings of liberty, providing for the common defense, and all that stuff in the preamble. Those are non-controversial, largely political goods that the Constitution has served well in its amended form to secure over the course of at least the last several decades. And I think that's good enough to support a commitment to the original meaning of the Constitution.
To answer that question, you need to divide it into two. First question is, why does the Constitution become law? Second question is, why does it continue to be law today? Answer the first question is very easy. Constitution becomes law because of an act of popular sovereignty, actually a series of acts of popular sovereignty, the original Constitution and then the amendment process. Then the second question is, why does it continue to be law today? And that reason has already been given by several of the people on this panel. That is, it's rule of law reasons. That is, once you make something law, in our system, it continues to be law until such time as it's lawfully changed. Now, of course, there will be various disputes about interpretation and construction that follow on to how to apply that law. But the basic idea that the law, once enacted lawfully, continues to be the law until it's lawfully changed is a very reasonable postulate of our system.
Elizabeth, in your comments, you talked about how maybe more people should be originalists and how you were going to try and help us host this panel at ACS. But my question is, why do you think more people should be originalists? Do you believe public officials and judges should be originalists? And what about private citizens?
Yeah, absolutely. And we did kind of do this panel at the ACS convention, but what was the title? It was "Let's Talk About Text." Has a little jazzier beat under it. But I think that absolutely not only should people from the left and right focus on the words of the Constitution, but I think that absolutely judges and public officials and private citizens should. Because, yes, the people who swear an oath to the Constitution, one would hope, would be very devoted to those words that they swore to uphold. But also, all of us live as part of the Constitution. All of us live in a country that is formed by the Constitution, and it frames our values. And so I think that, this is also where I take inspiration from the arc of progress that we've seen through our Constitution. You know, I wasn't included in democracy when the Constitution was written initially, but we expanded who is part of democracy through caring about the Constitution and changing its words. And so private citizens, I think, can take inspiration from that to see the values, the North Star, and the Declaration of Independence's great words that we are constantly struggling to make a reality for all. And I think that public officials would do well to speak in the terms of the Constitution because they resonate with people. You know, the average American cares about the Constitution. You know, there's I think an interesting point about, like, you know, you could talk to someone on the street about free speech or the Second Amendment, and they're not lawyers, but they know what you mean. You know, I would like people to have that resonance when we think about the rights and values of the 14th Amendment, but I think it goes to illustrate just how powerful the Constitution is.
And Professor Sachs, what are your thoughts on this?
So I think the Constitution is definitely for more than just judges, and if the Constitution is for more than judges, then originalism is too. I think one of the worst things that can happen to a legal system is for it to be thought of as just the province of judges. I think a while back there was a pamphlet that you could even get at the Supreme Court that was sort of explaining, you know, what is this thing for tourists? That would say, you know, Congress makes the laws and the executive enforces the laws and the Supreme Court interprets the laws. And I think that's actually not quite how it goes, because the Supreme Court or any court interprets laws only because a case has come up that they need to decide in accordance with the law, whatever that law might be. And they have just as much and only as much province to interpret it as anyone else has who needs to find out the legal answer to a given question in a particular case. When Chief Justice Marshall was saying that it's the province and duty of the courts to say what the law is, it's because they have to figure it out in order to give a legally appropriate judgment. That doesn't mean that their voice is the only voice at the table or that whatever the courts say goes. So originalism is for anyone who wants to know about our law, and that is far, far more, and has to be far, far more than just judges and courts.
Do you, Professor Sachs, do you think originalism encourages activism or restraint? And that came up in some of your comments, I mean, the panel's comments. And in answering that question, can you define those terms, activism and restraint? And Professor Mulligan, be thinking about it, because I'm coming to you next.
So can I define those terms? Not hardly. People use activism and restraint to mean all sorts of different things. At least one way of looking at it is activist courts are courts that are doing a lot of stuff, and restrained courts are courts that are not doing a lot of stuff. And I think part of the problem is that the Constitution requires judges to do only and exactly as much stuff as it does. Sometimes the Constitution tells judges, you're going to have to strike things down. If there's freedom of speech, then no, maybe you can't make it illegal for people to put out a movie criticizing a presidential candidate. That is something that you might have to involve yourself in the political system just to do your job as a judge to render the right decision in a particular case. On the other hand, it might mean that you can't interject yourself into a different kind of decision, some hotly contested area for legislation, whether in Congress or in the states. There might be some authorities that the Constitution does not reserve to judges. So originalism sometimes encourages and sometimes discourages judicial action. But a lot of what people mean when they talk about judicial activism is how independent are the judges? How much of their personal judgment is being exercised? You know, sometimes that too will come up. You can't decide whether a given search is reasonable under, particular situations without asking yourself a lot of questions. Different reasonable judges might come to different answers on that question. But the Constitution does not, in general, give judges the power to enforce legal rules of their own invention. Their job is to enforce rules that are, by and large, created elsewhere. And so in that sense, it's a very powerful restraint, not in the sense that it never lets them do anything, but in their choice of which rules to enforce is restrained by having a constitution that they themselves can't amend.
Professor Mulligan?
So obviously, activism and restraint are very rhetorical terms that don't have necessarily particularly precise definitions. But if we're going to say activism is like making stuff up, it's interesting, right? Because originalism was born out of a desire to give some weight to ways to not make stuff up, and yet one of the main criticisms that you hear of originalism is that this is just an excuse for people to situate, to dress up motivated reasoning and authority and get the results that they want. It's a way for conservatives to be activists in just a different way, right? And the truth is that any interpretive method that's not rotely mechanical is going to have the ability to be bent and twisted by people that are biased or have motivated reasoning or are too confident in their own abilities. And so, not even because they're trying to get the results they want in some conscious way, but because we all unconsciously read things to comport with our expectations, even if our expectations are not even what we like or what's good for us. So the nice thing, originalism in some ways encourages activism no more than any other methodology, though it's important to remember there's space for it. It also gives us the tools to restrain ourselves within the appropriate boundaries because that's such an important value to originalism. But in order to maintain those boundaries, we have to work very consciously and intentionally to be faithful to that framework. So basically, we don't have to be activist, but we have to try, we have to care, we can't forget. We can't just assume originalism will take care of it because that's what it says on paper.
So I'm going to ask each of you this question, but I'm going to start with President Wydra. And you pointed out in your remarks that Justices Ginsburg and Kagan have referred to the original meaning. And so what I'd like you to do is point to an opinion, any opinion, each of you, that you, if asked for an example of originalism in action done properly, what opinion would you point to?
So I think that's a great question, and I think, Justice Ginsburg has talked about reproductive justice and reproductive autonomy in a way that I think reflects the equal citizenship guarantees of the Constitution. And I think that's an important point to raise because one of the major criticisms of the right articulated in Roe is that it isn't rooted in the Constitution. And so I think that one of the quiet but perhaps revolutionary things that Justice Ginsburg has done, as is often her style, is to root that more directly in the Constitution by talking not so much about privacy, but about the idea that one cannot be a truly equal citizen as guaranteed in the 14th Amendment, as reinforced in the 19th Amendment, which we're going to celebrate the 100th anniversary of next year, if you cannot make the basic choice for yourself over whether or not to bear a child. And I think that that is a very powerful and yes, originalist articulation of Roe that she has written into some of her more recent opinions at the court, as well as having in her advocacy when she was in private practice.
Professor Sachs?
So the example that comes to mind actually isn't a judicial opinion. The arguments over the creation of the Department of State and the sort of so-called decision of 1789, whether the president could remove heads of departments. I think that the examples of the debates in Congress, not everyone agreed, not everyone came to the correct conclusion, but I think they were all looking at essentially the right questions. They were saying, okay, well, what does the Constitution grant by saying the executive power? And what does it take away by qualifying that in other clauses that affect the president's power? And what power does it grant to Congress in the necessary and proper clause? And so looking at this question not as just, what's the right way to run a government, that they also had to decide and very urgently, but what's the general rule and to what extent does the Constitution cut back on that in certain ways, and where can we look to find guidance on this? I thought it was an amazingly well-conducted debate, and really a reminder to us today, not only that Constitution is for congressmen to consider and not just judges, but also that we should expect that our representatives in Congress are having the same degree of care for constitutional questions as we would expect in a judicial confirmation hearing.
And Professor McGinnis, you have one for us?
I think the concurrence in Noel Canning was a really good example of originalism done right. Won't go into it in detail, but one question is, what does session mean for the purposes of the recess appointments clause? And the concurrence suggests that session only applies to the intersessions between sessions of Congress. I don't think that's obvious from the text of the Constitution. I think it becomes obvious from the history of the Constitution, including the use of the term sessions in other constitutions at the time. Mostly, it's important to understand that that's just the better meaning based on all of the evidence. And I think that's the way originalism should be done. So I think it's really a model of deploying the evidence. Moreover, it really relied on important originalist scholarship done by my colleague Mike Rappaport, and it shows the important division of labor, I think, between judges today who are busy and maybe not able to unearth all the relevant evidence, and scholars, and the important role that scholars have in setting a framework for the progress of originalism.
Professor Balkin.
Hi. I thought first by saying I strongly second Elizabeth's suggestion that there is a very strong originalist case for Roe and Casey, based on the 14th Amendment's prohibition on class legislation, and that a style of legislation that subordinates or reduces one group to another is in fact suspect under the 14th Amendment, and that is in fact the best way of articulating the originalist case for Roe. But if you want an originalist opinion that really shows how originalism should be done, the one I would choose would be Justice Harlan's dissent in the civil rights cases. I know you're all familiar with his dissent in Plessy, but the one in the civil rights cases is in some ways even more important. And the reason why is it correctly understands Congress's role in passing civil rights legislation, a legislation designed to protect the civil rights of everyone. It also correctly understands the role that the Citizenship Clause had in binding both the federal government and the states, and requiring both the federal government and states to protect equality. And the last thing I wanted to say about this wonderful opinion, it makes I could spend a whole lecture just on how wonderful this opinion is, originalist opinion, is that if the court had agreed with Justice Harlan in the civil rights cases, Plessy versus Ferguson would have been a preemption case, because the 1875 Civil Rights Act would have been held constitutional, and Louisiana's statute in Plessy would have been preempted by federal law.
So I just want to second that everything that Jack said about Harlan's dissent in the civil rights cases. It is an overlooked originalist gem. My particular case that I would uphold as an example of originalism done properly is one of Justice Scalia's less famous but most important opinions, and this is Crawford v. Washington, decided in 2004. I mean, it's a practical matter. Crawford transformed criminal procedure by establishing an entirely new methodology for determining when the use by prosecutors of out-of-court statements violates a defendant's right to confront the witnesses against him. The court had in previous decades held that the Confrontation Clause allowed testimonial hearsay to the extent that it was sufficiently reliable to be credited. Crawford, and together with Davis v. Washington, interpreted the Confrontation Clause to bar all statements whose primary purpose was to provide evidence against a defendant unless there was a prior opportunity for cross-examination and the witness was unavailable. Now, why is this so important? Because Justice Scalia is a conservative justice nominated by President Ronald Reagan, who nobody could be accused of having a normative desire to raise the cost of prosecutors of convicting guilty people. He did it because of his methodology. And Crawford is a methodological tour de force. Scalia concedes that the text, just considered in isolation, what's a witness, is somewhat ambiguous, and he has recourse to what I would describe as the spirit of the Confrontation Clause, the primary evil against which it was directed, the use of ex parte written examinations to produce evidence of guilt. He talks extensively about the trial of Sir Walter Raleigh and the degree to which that influenced founding-era discourse, about the benefits of common law procedures to protect people's individual rights. So I would uphold Crawford as an example of both the constraining power of originalism and the power of an example of originalism done properly.
Professor Mulligan?
This is a banal and imperfect answer, but I think a real sea change in how originalism was done in courts kind of came to a head in Heller, which, while being maybe kind of simplistic or opportunistic, or at least in the dissents in some places, the fact that the majority in the dissent were talking to each other using historical sources to make their arguments, and that was the dialogue, really. So I'm really talking about the relationship between the majority and the dissent. Was a moment where it became clear that you had to take originalism in text seriously, as evidenced by the fact that the dissent in Heller doesn't say, we would come out the other way because it's unjust, or because it's wrong, or because of present-day commitments, but they argue in the text and in the history as well.
Thank you. Okay, so my final question, then I'll open it up. As Evan just noted, Justice Scalia often said you don't get to pick your results when you're an originalist. So, Jack, Professor Balkin, I'll start with you. What is your wackiest originalist conclusion? And if you can, give us one that might not be consistent with your normative convictions. And I'm going to ask each of you this, and then we'll open it up to the audience.
Thank you, Judge. I'm going to answer a question about what kinds of originalist positions I feel that I'm required to take that are inconsistent with my politics, which some of you know are very liberal. And I would take one just from today's headlines, and that is the wealth tax. Wealth tax has been promoted by Elizabeth Warren, among others. It's a 2% levy on wealth. My view is that a straight across-the-board wealth tax of 2% will have serious constitutional problems. The reason is Article 1, Section 9, that says that direct taxes have to be apportioned by state population. Now, there are workarounds. After all, this is tax law, and what do we hire tax lawyers for? But provide workarounds. But they're rather complicated. I've spent a lot of time thinking about how you would work around Article 1, Section 9. But the key thing to understand is that if you don't pay attention to Article 1, Section 9 and the original meaning of Article 1, Section 9, you're going to have serious constitutional problems with a wealth tax.
Professor McGinnis?
Well, the opinion that in some sense goes to the question that we also have opinions that the other branches give, and I've worked on opinions that suggested that there is birthright citizenship under the 14th Amendment, and that's something I don't agree with, and I think, though, is quite clear from the legal meaning of the 14th Amendment. It's not that I think that birthright citizenship should not be given perhaps in some circumstances, but almost no other nation in the world gives birthright citizenship as a matter of its constitution, and you might think that's a very important matter to give to the democratic process. It's a very controversial matter now, but I think it's absolutely clear once one looks at the meaning of the 14th Amendment. I wouldn't have done it, but I think we are bound by it.
Professor Sachs.
So I see this is going in two different ways, the wackiest constitutional opinion and one that is against your policy preferences. In terms of policy preferences, I think that, or at least I can put this, I'm not persuaded that the 17th Amendment was necessarily a good idea that created direct election of senators as opposed to having state legislatures elect senators. I think there's something to be said for the political safeguards of federalism, and one of them is to have the state legislatures themselves represented. Now, there are other arguments against it. David Schleicher at Yale has argued persuasively that it sort of nationalized state elections, but that's not a very wacky interpretive claim. The text is pretty clear right there. So in terms of wackiness, I'd say, at the risk of typecasting myself, that Erie is wrong, and that there is no such thing as federal common law. They had a long debate in the late 1790s, early 1800s about the common law in the federal system. And both sides were pretty well agreed that what we did not have was any form of common law that judges could make up, that preempted contrary state law, and that provided for federal question jurisdiction. And those are the three hallmarks of federal common law as it exists today. Happy to say more in the Q&A.
President Wydra?
Yes, thank you. So I think, I think the majority in Heller is bad originalism when it comes to the Second Amendment, but I think good originalism applied to the 14th Amendment cannot help but come to the conclusion that there is some sort of individual right to have a firearm, at least in your home for self-defense. I wrote a brief that included both Jack and Randy Barnett and a co-founder of the Federalist Society, as well as members of ACS, that came to that conclusion. Now, of course, I'll save myself by saying, I think that my definition of what then constitutes reasonable regulation of that right is probably a lot broader than some other people's, but the fact that there is that right, I think, is undeniable from the 14th Amendment's particular history and words.
Professor Mulligan?
So I'm not 100% sure of this because I haven't gone all the way into the research necessary, but my wackiest conclusion is that copyright law might not constitutionally be able to protect art. And this is, I tend to think, to fair disclosure, I tend to think that copyright law is too expansive, but this is the fact that it's unconstitutional to protect art is so wacky and different that it sounds completely preposterous. So it makes me feel nervous saying it. So the text says, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So at the time, science tended to mean knowledge. Useful arts was technical craft, right? And it contrasted with fine arts, right? So fine arts is notably not there. Writings, this is the part that requires the in-depth research that I'm not absolutely confident about. You could expand this to other things. But here's what founders knew about paintings, founders knew about sculptures, and yet the Copyright Act of 1790 protects books, maps, and charts only, because kind of a purposeful reading, or what people were thinking about at the time, was how do we encourage the dissemination of knowledge, not so much to protect creative works and creative people. So I am hesitantly nervous that it may not be constitutional to use copyright law to protect basically 95% of the things we protect copyright law with.
A lot of people are going to be unhappy with you today.
I know. This is...
Thank you. Okay, Evan?
So I'll give two quick answers. One that's inconsistent with my own normative convictions, one that I think will strike a lot of people in this room as pretty wacky. So the one that's inconsistent with my normative convictions is I think that the First Amendment probably only applies to Congress consisting of a Senate and a House of Representatives. Therefore, it does not constrain the President or any other federal constitutional actor. I hasten to add that I believe that the 14th Amendment's privilege or immunities and due process of law clause protect the freedom of speech at the state level. But I don't think you can get to the conclusion that the First Amendment, except to the extent that the First Amendment bars acts of Congress that violates the freedom of speech and the President applies it, you can stop that, independently constrains the President. So that's the one. The other wacky one is that I think the state action doctrine, which holds that the 14th Amendment generally doesn't require states to do anything, just not to do things, is probably wrong as a matter of original meaning. I think that there is overwhelming evidence that the framers of the 14th Amendment and those who ratify it would have understood the denial of equal protection to cover state omission to protect people against private violence, particularly violence that was initiated by the Ku Klux Klan. I actually think that there's an overwhelming case for this. And so DeShaney v. Winnebago County Social Services, which held that the Constitution basically has nothing to say when a state welfare agency fails to protect an abused child from his father despite getting repeated notice that this kid's rights were being violated, is probably wrongly decided.
Okay, thank you all very much. So there are some mics in the room. We're going to open it up to questions. I want to remind everyone that questions typically have a question mark at the end. And please keep them brief so we can hear from the people that people came to see.
I'm over here. Over here. No, other side.
Okay, over there. All right.
Good.
Hey, so thank you for triggering me, ladies, and I thank the Federal Society for the safe place. But I do want to talk a little bit about, or ask you a question about, not talk about, the reputation of originalism in the left when you foundationally say things like, well, it was just white men in the 1700s, or it was a certain race in the 1700s, or it's just certain income in the 1700s. None of us were alive then. They're not here to speak for themselves. In 2200, they'll be criticizing us. Do you think that foundation should be put up to a popular vote? I'm just concerned about the vilification of it when those things are the starting descriptors of who did it, because it puts it in a hole to the people that haven't had civics, haven't had law, and the population you're concerned about. So how do you, or do you really think we should rip it up?
So my view has been that originalism is correct, right? But I agree with your question, which is when that is the way that a lot of people think about the Constitution and constitutional questions, that requires people who don't think that way to do work to say, here's why you should think about it in a different way. And just saying, I'm going to logically prove to you this is how law works, isn't going to have that resonance that makes people kind of change their mind and change their view. And that's why I think it's really important to hear the concerns and respond to what they are, which sometimes, as I said, is that the founders were not properly constituted. But I think a lot of the criticism comes from a present day sense that people on the right just do not give an F about minorities, about women. And you can do a lot of work by actually taking the concerns into effect and listening to what people experience today and responding in a way that is still consistent with the fixation thesis and the constraint thesis of originalism. And that's really my main thrust here.
I'd just like to second, in some sense, what Christina said. I think it is a serious criticism of the original Constitution. Indeed, I think it is the most serious criticism of the original Constitution, particularly the creation of slavery, at least the non-elimination of slavery, and then particularly the fact that African Americans and women were not included in the ratification process. I think there are answers to that now after the 13th, 14th, and 15th, and 19th Amendment and 19th Amendment. Everyone has the rights of white males at the time. I think also the idea that judges can correct and can figure out what the Constitution would have been is extremely costly and will lead to worse results than we've got today through originalism. But I think that's a serious issue, and so I do think originalists should take it seriously and respond to it. We should not vilify our founders, but we should understand the defects and say that despite that, originalism is the way to interpret the Constitution today, but it's an argument that needs to be answered.
Yeah, I would just add that, I think that in some ways, while I don't like when the left caricatures the right's, doing a seance of James Madison to figure out what originalism is, in the same way, I don't think that the left wants to tear up the Constitution. I mean, this is a totally pop culture reference, but liberals are flocking to pay thousands of dollars to go see a musical about Alexander Hamilton. I mean, the idea that there's a pure vilification on the left of the founders, I think, is wrong. But I think one way that particularly originalists can push back against some of that idea that we're talking about a document created by old white men in the 18th century is to talk more about the Constitution as it was evolved over time. I know I'm a bit of a broken record on this, but I just think it's so important. And the fact that when we talk about founders, we're talking about our second founders. We're talking about the people over time who are not just 18th century rich old white men. And I think that's important.
Yeah, nothing that I said about a promissory obligation earlier applies to the Constitution before the Reconstruction Amendments. I just want to stipulate that. I think there were compelling reasons for those who doubted whether they could take an oath and consistently follow the Constitution as it was originally written in 1788. I think that the best way to deal with that objection is to concede a certain amount of its force and explain how the Constitution has changed over the years through amendments that are valid for all intents and purposes purposes as part of this Constitution. When I refer to this Constitution and say that's the Founders' Constitution, that's the Founders' Constitution as amended.
Professor Lawson?
Hi, thanks. I was terribly disappointed that the panel stopped at the third power. So I want to see if I can push you to the fourth and fifth powers. And this follows most naturally after John McGinnis's comments, so I'll formally address them to John. The fourth power would be, in order to apply any notion of legal methods, it seems to me you have to know what it is you're applying the methods to. And even within the universe of legal instruments, there are lots of different kinds of legal instruments. There are statutes, treaties, corporate charters, powers of attorney. And the rules of interpretation can be subtly but importantly different for all of those. So question one, fourth power for John. To apply legal methods, do you have to have a categorization of the thing to which you are applying those methods? And then the fifth power is that, John, you pointed out that a lot of originalist work is establishing what the best understanding of a constitutional provision is. Is that good enough? I mean, if this was a criminal trial, it certainly wouldn't be good enough to put someone in prison. Is it good enough to establish a constitutional norm that 3 steps down the road might result in putting someone in prison?
Oh, I think those are great questions. I think, so let me take them in reverse order, if I might. I'll go to the fifth before the fourth. I think that is a tremendously important question, and the issue is how much evidence should be required for a judge to displace a decision of another branch. And that seems to me a question of judicial power, and that is itself an originalist question. I have my own views about that, which I won't go into here at length, which is that the evidence, they have to have a kind of clear and convincing evidence before displacing it. I think we see some suggestions of that actually in the way judicial duty worked before the Constitution. We see some evidence of that in the way Alexander Hamilton said we're going to strike down statutes only if they're in irreconcilable variance with the Constitution. But I agree, the quantum of evidence is a question. I would just say that it is a question to be answered according actually to the original Constitution. So I wouldn't see it as a separate fifth power question. The fourth, I think, is something of a fourth power question, because you're absolutely right. There can be a lot of different kinds of rules. Now, I think I want to be cautious here. A lot of interpretive rules, expressia unius, apply to all legal documents. And a lot of those apply to the Constitution. The harder questions are, well, are there some specific kinds of rules that don't apply to a Constitution? And are some specific kinds of rules that do apply to a Constitution? And actually, if you look back at the debate over the Bank of the United States and the opinions of Randolph and Hamilton, in some sense, that is their biggest debate. And that, I guess, is a question really almost like a common law of interpretive rules. What kind of document is this? How do we fit it in best to the set of interpretive rules? What's the best analogy? Do we understand the Constitution just as a super statute, which I think is the way most people understood it at the time? But what differences does that mean? But precisely because it is shorter, does that mean we do not apply certain interpretive rules? That was Hamilton's argument in certain respects. So I agree, we do have that fourth power question, and that I think is the hardest issue about the decision about what interpretive rules to apply to the Constitution. There are a set of interpretive rules that you really just can't read off, and you have to make these kind of analogous arguments. And then again, you go back to my basic point, which I think was accepted at the time, the Uber rule. I don't know, you call it the sixth power rule, is we do the best we can. We take the best evidence, we use the best analogies we can, and we go with that.
So if I could jump in, I mean, one way to avoid going on from 4 to 5 to 6 and constructing the ordinals, which you didn't know you were going to be doing this morning, is to say, look, the law is a seamless web. there are a whole lot of legal rules out there. And it so happens that the Constitution is a written enactment, but it's part of a broader tradition, a broader common law tradition. We're a common law country. And so there may very well be lots of legal rules that help step in and answer questions that the Constitution either does not answer or sort of can't answer in itself. So when we're talking about what are the right interpretive presumptions when we're dealing with a statute as opposed to a treaty, as opposed to a contract. Well, none of those are written out in the statute, in the treaty, in the contract. They might be. Sometimes you get rules like that. But most of the time, you're drawing from an existing tradition of law. When the founders adopted the Constitution, they were not writing on a blank slate. They did not declare year zero and, remake the calendar and, declare the Festival of Reason and everything that went on in the French Revolution. Instead, what they did was said, okay, we've got existing states, we've got an existing confederation, we're going to supersede it in certain respects, we're going to play a little fast and loose with the Articles Amendment rules, but we're otherwise maintaining a lot of existing aspects of that tradition, and those common law rules and those other rules still continue and bind to the extent that the Constitution does not supersede them. So I think that a lot of the sort of iterative problems can be solved or at least eased by recognizing that the Constitution was not the only legal game in town, and there was a whole lot of law on the books already that indeed the founders were crucially relying on to make the thing they were adopting work.
Over here.
Well, thank you, Judge. My name is François-Henri Briard. I'm the chair of the French chapter of the Federalist Society.
Oh, now you're in trouble.
I'm sorry.
Thank you. And I'm here with a group of lawyers, a delegation from Paris. I have two short remarks, one for Professor Balkin and one for Professor Sachs. To Professor Balkin, I would like to say thank you, because this is exactly the way we do interpret our Constitution in France. What you said about living originalisms, we do refer to the original intent. And I remind you that our Constitution is not only the 1958 Constitution, but also the 1789 Bill of Rights. But also we do remember that our interpretation is for people living in 2019. To Professor Sachs, I would say respectfully, using the favorite words of my friend Antonin Scalia, I dissent. I dissent with what you said about the French constitutions. You say, you presented the French like having a different constitution every 10 years, but I would like to remind you that not only we saved America, we were America's. We were America's first ally. Not only this, but we did invent the principles on which current originalism relies, especially separation of powers. And we do refer to these principles in many opinions of our Conseil Constitutionnel, the Constitutional Supreme Court. So your debate this morning was very interesting for us, and I would like to thank you very much.
Professor Sachs, do you want to comment on that?
Oh, just to say that I very much take the point that no legal system ever truly succeeds at removing root and branch. I mean, there's a famous, maybe apocryphal statement by a judge that I don't know what the civil law is. I only know the Code of Napoleon. Like that, yes. No one could ever really believe that all the way down because they understand legal instruments in a certain context. I think the point really about the United States is just that there are no constitutional innovations post 1788 that we accept as innovations. There may be amendments that are very much part of our Constitution today, but they're the official answer for why is the 14th Amendment part of our Constitution is because it was proposed by the necessary majorities in each House of Congress and properly ratified by the states according to Article 5, not because of some official break in the chain of legal authority, which many other countries have had subsequent to 1788. It is that I'm trying to distinguish America from, and certainly not from our alliance with France.
And Professor Balkin, it sounds like you'll have an invite to France, but do you have any?
I'm available.
Yes, thank you, Judge. I'm Judge John Curry from Chicago, and I wanted to address a concern referenced by Professor Mulligan, and that is your concern in this dynamic talking with your students. Isn't it wrong, if we're going to look at our Constitution and the concept of originalism, isn't it a problem if we're addressing this as apologetically as a result of the work of so-called dead white males? I mean, is the Constitution and the writers of the Constitution approachable only if we conceive of Alexander Hamilton as a rapping Puerto Rican? I mean, I take the opposite view. You said refer to a golden age. It was, in fact, a golden age. The writers of the Constitution, the authors of the Constitution, were inheritors of the Scottish Enlightenment, the product of a rationalist development in law and in philosophy. You know, these were great thinkers, and there is greatness in that generation that wrote the Constitution. Shouldn't we be rooting our originalism in extolling the virtues of our founders as opposed to the opposite? Thank you.
So to be clear, when I repeat this dead white men language, it's not because I think that's the way we should be thinking about it, but that when a large percentage of the population thinks about something in a certain way, it necessarily becomes something that you need to address head on and talk about and take seriously. Even if you disagree with what it is, to sort of say, you know, I'm just not going to talk about it, leaves a lot of people that might be potential allies who might say things that are potentially interesting or relevant that could teach you something even if you still disagree with them kind of to the side. You know, the reality, I think, is that the framers, the founders, many other people in America's history were extremely brilliant at law and philosophy, designed an amazing governmental system, and also, for reasons that I think make sense given the cultural context of the time, still owned people and believed that women weren't smart or capable enough to vote. And the fact that that's true means that there is a mixed record in the past, just as there's a mixed record in the present, and there's a mixed record with any complex human being that tries to do anything meaningful with their life, because we're all human beings trying our best to make sense of the world, and sometimes we're really smart, and sometimes we're brilliant, and sometimes we get it wrong. And the right way to approach American history or any history is to recognize the whole complex picture of who we are and what we've been doing.
Professor Balkin, do you want to comment?
Yeah, I want to take a page from the Enlightenment too. But first, I'll start with Lincoln. Lincoln's talking about the Declaration of Independence, and he says, you know, when these words, "all men are created equal," are written, they're not true. It's just not true. People are held in slavery. The conditions are those of great inequality. But Lincoln says the words are put there so that someday they might become true, so that each generation would see that they had an obligation to redeem the promise of those words. This is an Enlightenment idea, the idea that each generation can improve on the past generations and can add something in their experience as times change. This also is the way we should think about our founding as a great experiment, but also a great success, and the various ways in which we've improved the American experiment in democracy, especially during the period of Reconstruction. And that we should see our Constitution not as something that we are chained to, or as simply an object of our obedience, but as something that we have been bequeathed, something that we have been handed, something which is our duty to redeem in our own time.
Chris Green from Ole Miss. I have a question for Professor Balkin. Mark Tushnet has said, I think it was on your blog, he suggested that your embrace of originalism is some sort of elaborate piece of performance art, that you're engaged in this very, very long con at this point. And I'm wondering...
A French performance artist, no less.
So, are you? And can you... Can you do something more vivid to demonstrate that you're not?
I guess
you're
I would
amazing.
say that I don't think Mark Tushnet's entirely reliable in the things that, either the things that he's written about me or many of the things he's written on my blog. Otherwise, I think he's a wonderful fellow and we have wonderful discussions, but I think Mark regards me as an exception that he is trying very hard to get rid of in making a larger argument. And my argument with him is that this is not the right way to think about our constitutional tradition. So this is just a disagreement we have.
Thank you.
Cameron Atkinson from Connecticut. I had a question to the panel in general. So a lot of the provisions of the Bill of Rights developed through the customs of English and practices of English common law and ultimately are enshrined in text. At what point, in terms of Jefferson's letter to Madison and in terms of the dead hand, at what point does the customs and practices definition stop becoming relevant, especially when you're dealing with a provision that you take the Fourth Amendment that literally uses the word reasonable? And how do you define reasonable if it stops at its enshrinement in the Fourth Amendment?
So one thing that I might venture on that point, I should say at first, I'm not a Fourth Amendment expert. So, my research into the subject is not as extensive as I would like it to be. But there's at least some argument, and some folks have been making this argument recently, that the Fourth Amendment reasonableness requirement has to be understood in light of the available remedies. So the Fourth Amendment was not introduced as an exclusionary rule. Indeed, the exclusionary rule, I think there's a good deal of evidence, evolved somewhat later. The remedies that were available for the Fourth Amendment primarily were damages actions against individual officers. If an officer breaks into your house and they say, I was trying to find evidence of a crime, you say, well, where's your warrant? And if you don't have one, I can sue you. And the fact that you're an officer won't save you because there's the right of the people to be secure in their persons, houses, papers, and effects from unreasonable searches and seizures. And what counted as, in part, an unreasonable search and seizure would be something that was illegal if the officer had not been an officer. If they'd just been some private investigator rooting through your stuff, you would be able to sue that person for breaking into your house and searching through your stuff. And the fact that they're an officer is no protection. So there's a sort of private law definition of what the rights of privacy were. If that's right, and I don't know that it is, but if that's right, it gives us a pretty clear idea of how we would apply it to different circumstances. So you have situations like, what do we do when people are using infrared cameras to look at the temperature of the outside of your house, as the Supreme Court had to decide a few years back? And there's one way of doing it, which is just to design a sort of realm of privacy that the court is going to intuit and thereby protect against all infringement. Another way of doing it is to say, well, what does private law say on this matter? If your worst enemy hired a private investigator to go photograph the outside of your house and figure out how warm or cold it was, would that be illegal? And if not, maybe that shows us something about whether you can expect to have that information private or not, and what is actually a reasonable search and seizure. So again, I don't know if that's true, but many of the rules of the Bill of Rights were designed not just to preserve a particular customary arrangement that might then break when presented with new facts, but to enforce a particular kind of rule that applied to current facts. You use current facts as inputs to the rule, and you get an output. And that rule stays the same over time, even when the facts that you feed into it might be different.
Just to build on that a little bit, originalism really needs to take seriously the problem of compensating adjustments, particularly in the context of the Fourth Amendment. It's one thing to say that the exclusionary rule was probably something that was just developed by the Warren Court because they thought it was a good idea as a matter of policy. It's another thing to say, well, we should return to how the Fourth Amendment was understood circa 1789, where the assumption was that certain remedies would be available and certain immunities from constitutional suit didn't exist at all. Now we have qualified qualified immunity. There's a good argument that qualified immunity has no grounds in the common law as it existed at the founding. So what do? Do they get rid of the exclusionary rule? Do we wait for the abolition of qualified immunity to get rid of the exclusionary rule? Do we insist upon doing them both at once? These are hard, complex problems. I don't think they lend themselves to an algorithmic answer, but I think it's important that originalists confront them and think about them before taking any sweeping measures to get rid of what is obviously an unoriginalist rule.
Thank you. Thank you very much, panel. My name is Laz Pinter. I'm from Danbury, Connecticut. And the one thing I never thought would happen at a Federalist Society convention is to have the opportunity to thank the French for saving our country. So my question is, and this follows up on something Governor DeSantis said, which I think is a very risky and critically important issue in the last 1 or 2 years. That is the nationwide injunction effort that's been going on. I wonder if the panel could comment on whether there's anything in the Constitution that addresses the legality or illegality or application of the use of nationwide injunctions and anything that could be done within the language of the Constitution. Thank you.
Let me first say that if you're looking for expertise on this issue, on January 29th at 12:30 p.m. at Duke Law School, we will be having a debate on the nationwide injunction with Professor Sam Bray of Notre Dame and Professor Mila Sahani of USD. I'm looking forward to learning more then. I'm honestly not sure whether the case or controversies language of Article 3 says very much about nationwide injunctions. I believe that Professor Bray has argued that it does, that they are unconstitutional. It strikes me that the better arguments against them really follow from the civil rules and the rules of equity. That Rule 17 requires that a plaintiff, that a case be brought in the name of the real party in interest, and that if you're acting for the benefit of another, you have to have a statute that says you can, or various other meet various other criteria. Rule 23 has various restrictions before you can represent a class as a class rep. I think that it's those things that make the nationwide injunction complicated, and not necessarily rules in the Constitution. Over here.
There hasn't one word that hasn't come up in this conversation, although I think it's been touched upon slightly, is legitimacy, and the advantage originalism gives to the idea that the rules and laws are legitimate because they're not made up. And my question is, to the extent there's another interpretive method besides originalism, how do those interpretive methods have legitimacy for the populace? Some of you have talked about that the people talk about the Constitution. And I'd like to ask this question a little more, sharpen it, in that President Wadry just talked about how reproductive rights are a natural exposition of the 14th Amendment, but you also praised the amendment allowing women to vote. Was that amendment necessary under your originalist view of the 14th Amendment?
Thank you. And just to be clear, you don't have to call me President Wydra. I appreciate the judge saying
I like it.
You don't really have to. But, I think that, legitimacy is important. And I think in some ways, that's why we have something of agreement, as I mentioned, among the Supreme Court justices that, obviously you start with the words of the Constitution when you're doing constitutional interpretation. If they just got up there and said we can do whatever we want, they're not going to do that. You can do it to the fourth or the fifth or the sixth power, but it's not that deep. You start with the words of the Constitution. And I think that legitimacy is part of that. Do I think that the 19th Amendment guarantee of the right to vote for women was necessary after the 14th Amendment's guarantee of equality, in the same way that the 15th Amendment was passed to ensure that people of color were not denied the vote because of racial discrimination? Sometimes we got to say things a few times in the Constitution to make it clear. I don't think there's anything wrong with that, and I think that the idea of women being included in the 19th Amendment in democracy also has greater implications. Professor Amar has written about this, that the idea of being able to vote also involves being able to serve on a jury, and the way that being a juror and being a voter have greater implications for what it means to be a citizen in democracy. So I don't know if that gets to your question, but I think that legitimacy is something that's important, and that's why I think it helps for folks on the left as well to argue rooted in the text and history of the Constitution, because I think that, you know, that's something that we can all agree on, at least as a starting place. And I think if someone says, I don't care, I'm going to do what I want because I think it's good policy, as opposed to, I think that we should pass this policy because I am guaranteed this equality in the words of the Constitution, I think one of those arguments is a little more powerful.
Professor Balkin.
There were people who did argue, by the way, around the time of the 14th Amendment, that that the privileges or immunities of citizenship included the right to vote. That argument did not win out. The Supreme Court rejects it in Minor versus Apperset. But it wasn't a crazy idea at the time. Many people thought, in fact, that is the best interpretation. But one reason why we have amendments to the Constitution is when arguments lose. They can be resuscitated again. I gave the earlier example, I was talking about the taxation. The Supreme Court had upheld an income tax during the Civil War. The Supreme Court then in Pollock basically struck down that income tax. Well, Pollock was wrong. It was just incorrectly decided. But the 16th Amendment essentially restored, or not completely, but helped to restore the correct interpretation. This point is the point that Steve Sachs has made, and I agree with it. The Supreme Court is very often wrong. In fact, throughout history, the Supreme Court has more often been wrong than it has been right. It's very important when we think about our Constitution to understand that each of us has an obligation to think deeply about what we think our document means. It belongs to us. It doesn't belong to the Supreme Court. It's very important that each of us make our claims on the Constitution to each other. Because, in fact, if we don't do that, the Constitution will be taken from us. It will no longer belong to us.
I just want to note that Professor Balkin said that, not Judge Thapar.
So I'd like to focus on legitimacy and originalism's importance to legitimacy. I think one of the most important aspects of legitimacy is the sense that we, the people, are sovereign, and we, the people, are sovereign, must ultimately be sovereign over our fundamental law. So it is absolutely crucial that the Constitution contain an amendment process so that we, the people, through supermajorities, can change our law and rule ourselves. Originalism is absolutely crucial to protecting the amendment process, because if we didn't have originalism, could be judges who could amend the Constitution, and indeed the wind would be taken out of the sails of the amendment process. People would try to do this through judges and judicial appointments rather than through collectively making decisions themselves. So we think that our popular sovereignty here and now is important to the legitimacy of our Constitution and our whole political system. Originalism is at the foundation of that.
Well, unfortunately, we need to stop. I know we could go all day with this panel. What a phenomenal panel. So please give them a round of applause. And thank you all very much for being such an attentive audience.